understand why you were still pushing your luck. You were supposed to register immediately upon doing the 3 days as a condition. When did she do the 3 days, please?
September 20th is when she went in.
This is where the timeline starts to matter. In court, compliance dates are everything. Missing even a single day on mandatory programs can be grounds for revocation. The judge is clearly tracking the dates here.
And that Monday, I think, he reinstated her, Judge.
Yes, Judge, it was September 20th.
She did it. She was released on when? The 21st.
The 23rd. 23rd is when she was released.
Released the 23rd. She was supposed to register immediately, starting the IOP. And what day did she register?
Yesterday.
Says her probation officer told her she had a month.
I told you, here.
Notice the judge's tone shifting. Judges often balance empathy with accountability. Do you think the court is being too lenient or just trying to give her one last chance? Comment below. We're curious how you'd handle this.
What you were supposed to do. I'm tired of playing this game, Andrea.
At least she's registered.
It's like, you know, when this is what happens when you're too nice. It's over and over. People take advantage of you like crazy. It took 1, 2, 3, 4 weeks for her to sign up for IOP, Andrea. 4 weeks.
Can you, since she's already registered?
No.
An ankle monitor plus a surprise drug test? That's the court's way of verifying compliance in real time. This is a classic escalation. Monitoring plus testing equals 0 wiggle room left.
I mean, I'm done with this. I'm just, what?
Let her see if she goes, if she attends. I don't have there's not much that I can say. I don't have much to stand on. But
She doesn't take us seriously.
I'm hoping that you will allow, since she's already registered, you'll allow
Let's
her.
do this. Let's do this.
Because she has an ankle monitor on. That's on. It's
I'm
on.
going to send her for a drug test right now.
Okay.
I want to see if anything that she's going to test positive for. And then
I can send her for her.
right now I want to send her for a test. And then I guess we'll talk when she comes back. Because first things first, I want to know if she's clean. If she's not clean, it's over.
Okay.
That's it. But if she's clean, then we'll talk about how we go further.
They
But-
send her back here.
Yeah.
How long? So I know how to manage everything else. That
I have your cell phone, right?
Yes.
I'll text you when she comes back.
Okay.
And I don't know. Just take a seat for me, man.
Thank you, Judge.
Thanks, Andrew.
Go to Ms. Ramirez.
Absolutely.
The state position is that we follow the recommendation of the
Yes.
probation department. Either feels A, she's reached a point where they can no longer help her and she needs that higher level of care than the probation department can give, or B, if the probation department feels that they can still treat her, we follow the recommendation of the probation department, B being Texas.
And they requested a 6-month extension, but her last been under 7 months.
But Judge, if she registered for the classes, there will be completed in 6 months.
I'm not doing a 6-month reset for her to do one class a
We
week.
can bring her to court. We can bring her to court for status updates. I'm 100% on board with that. I think that that's actually a very good idea. But what I'm saying is that the probation department feels that she could be helped with the IOP and SOP. That's my understanding. Please correct me if I'm saying something wrong. My understanding is that probation department feels that they could help her with the IOP SOP. I think that to her defense, nobody told her she needs to register, at least as far as I'm aware, 2 to 3 times a week. So
I told her last time we were here.
Not when we approached, because I was with her,
Yes.
Judge.
I told
No,
her.
I was with her and I don't remember you saying that.
I told her what you need to have done.
Listen to the judge's analogy about pushing like a child. This is a legal tactic to frame the defendant's behavior as manipulative. It helps justify stricter resets. Would you agree the court should shorten the leash here?
And then this is what you registered for. When you come back, this is what we're going to end up doing. Regardless, look, regardless.
What I'm saying is, since the probation department feels that they can help her, if she can register to one of the three, and I'm gonna bring her up here with, if you decide to allow her to continue, I'm gonna bring her up here and we all talk so everybody's on the same page. If she does it within like a week, not a month like we did last time.
I'm not ever going to reset her for over 2 weeks at a time
And that's
because I
fine.
can't trust anything to happen.
And that's fine.
And Mr. Lindsay, unfortunately, the way it works is that it's unfortunately, like a little child. They push and they push and they push. And it's truly, it's childish because they push and they push to see how much they can get away with. And as evidenced here, you sign up the day before court.
This is all predicated on if the court does not rescind its order for supervision.
What I'm going to do now is I'm going to reset her for 1 week. She has 1 week to sign up for the 3-time-a-week course. She needs to come back, show us that she's done that. And then after that, I'm going to set her off 2 weeks. Every single 2
Can I bring her up
weeks.
here? So
Sure.
I want her to be part of the conversation, so if she comes back and she doesn't do, so nobody can, so there's no possibility of saying,
I'm so over this, it's just ridiculous. Come up, Ms. Ramirez. So I will indefinitely set this case off 2 weeks at a time to make sure that it gets done. Because I can't do 4-week resets anymore, unfortunately. So we are now going to have to micromanage just I don't think that this is right. And I don't think that this is fair because it really spits in the face of every single person who does a good job with this program. And what you're doing now.
For weeks of delay and only signing up the day before court? This is the kind of thing that makes judges pivot from rehabilitation to punishment. What do you think? Is this a last warning or the prelude to revocation?
Is not what this program is designed to do, and it really violates the spirit because this is a program that's supposed to teach you right and wrong, teach you how to act in the free world, and you've done everything against that. I mean, for you to sign up for the class 1 day before court, it's just, it hurts. And it's shameful. Because when I told you, last time you were here, I told you that I wanted you to sign up immediately after you were done. And you sat there and you waited. Not 1 week, not 2 weeks, not 3 weeks, 4 weeks.
Oh, person's calling back.
So now you've shown me that I can't do long resets on your case. So if you fail one more time, if you ever fail to attend a meeting, if you ever fail to whatever you need to do, you will be out of this program. I will not do this again, and I will immediately.
Now the judge is laying down the final rule. 1 week to sign up, 2-week resets, and automatic trial if she fails. This is a textbook last chance scenario. Watch how carefully he spells it out, so there's no confusion later.
Immediately set your case for trial. You have 1 week to sign up for the class that's 3 times a week. And thereafter, you will get 2-week resets every single time to show me that you have attended this class 3 times a week. If you fail to go one of those times in a week, because it's the class is designed for you to go 3 times a week, every week. And if you fail to do that, that's it. Do you understand?
Yes, sir.
Judge, just to make sure we're all on the same page. Judge is asking you to go back to that list that you have and find a place that offers the program IOP 3 times a week. What are the requirements? Is SOP once a week or,
But she
okay,
has to complete IOP first.
right. So you have to go back to the list, find a place to register for IOP that does it, that meets 3 times a week. You do IOP, and once you're done with IOP, you find SOP that meets once a week. And you have to have,
90 days. Okay.
right, and you have to be registered in the IOP that meets 3 times a week by next court setting, which will be in about a week.
Not about exactly a week.
Okay, do I have it
Next
correct?
Wednesday.
Do I have it correct, Judge? Right, okay, so do you understand that?
Yes.
There's not gonna be another chance. Okay.
State has nothing further, Judge, for the court.
See you in a week.
Thank you, Judge.
Morning, Mr. Dunham. How's jail?
Terrible.
Great. That makes me happy. Because you got to understand, the worse of an experience you have, the higher likelihood when you do eventually get out, you'll think, if I do this, what's going to happen? If I say this, what's going to happen? Because that is the most important thing. You got to understand, we value public safety. It's really, really important to us. So you're here now because it looks like you picked up a case out of state and you want me to set you a bond. Is this right?
Yes, sir.
You need to understand that my only concern are two things. Number one, are you a danger to my public? And number two, if we set you a bond, are you going to go back to the jurisdiction that you wanted from?
Yes, sir.
Those are the two things that I'm concerned about. So, what's he wanted for out of state?
He's wanted out of South Carolina for robbery.
Robbery?
Yes, Judge. State would be opposed to a bond. He's currently has an open case of engaging in organized criminal activity. He's also on deferred for a third-degree felony theft, which he has not yet made the bond collectively of $50,000. He's also had a prior evading with a motor vehicle, misdemeanor evading motor vehicle, criminal mischief, and a theft. And it looks like based on the dates of each charge is that they're slowly escalating. It started with catalytic converters where he's using electric saws to steal them, but in the last evading is that he was also driving a stolen vehicle, and obviously now he's using weaponry or threats. And so based on the fact that from 2022 to now that he has been charged at least 6 times, 3 of which are felonies, and the fact that he has 2 open cases that he has not yet made bond on, is that he's a definition of a flight risk and safety risk. So I would be opposed to it.
Judge, Mr. Denham is requesting a bond because he has finals on Monday.
Finals?
Is a sophomore, major in nursing at Southern University in Baton Rouge.
Are you really in school? Really? But you're in Houston. You have finals on Monday?
No, I came right with this.
Keep it down, please. I'm going to read something to you real quick, okay? And this is from what I'm reading now. This is from the magistrate. Motion for bond conditions, Harris County, none. Defendant has a hold. 10/16/24. Officers conduct an undercover sting crime suppression operation to catch suspects who are engaged in organized criminal activity, bank juggings. Officers use bait victims, undercover officers posing as bank customers, and bait vehicles. 3 suspect co-defendants, DeLeon Dunham, Messiah DeLeon Dunham, and Treventi DeMarcus Hilliard attempt a bank jugging on 1 bait car, but are unable to break the window. Shortly thereafter, they conduct a bank jugging on a 2nd bait car and this time break the window. Bus signal given, and the officers execute a vehicle containment technique and a felony stop and apprehension. All 3 suspects, defendant in possession of criminal instruments. You're on probation for a 3rd-degree felony. You have an open robbery out of a different state. Let me ask you again. Do you really want me to set you a bond?
I was just asking if it was possible.
No. You got to understand, at some point, we really, really value our public safety. Mr. Dunham, we are going to do everything in our power to protect it. And if I give you a bond, you may very well pick up did you say 6? How many charges?
Total in the course of the last 2.5 some odd years.
6?
6.
Sometimes we have to protect people from themselves because of their own personal. So, Mr. Dunham, I'm sorry, but I really think that you are a complete danger to our public, so I can't do it.
All right.
I'm sorry. But
The local, it's likely going to get reset for Tuesday, then reset again. He's set for preliminary appearance upstairs, so it's just an arraignment, but it's likely going to get kicked out again for discovery. And so I'm just letting.
here's the deal, though. You need to understand that you have not made bond on your felony case. Okay, well, here's the deal. The problem is that while you have not made bond, your case here, the fugitive case, remains in a holding pattern. So the time that South Carolina would normally need to come get you is told until you make bond on that felony case. The other thing is that you're also on, Dave, where was he on felony probation from?
On deferred adjudication out of the 338 District Court for a 3rd degree felony theft.
I wonder why I can't even see that. Have they issued a motion to revoke on that one as well?
No, they set. Well, for some reason it says to hold on JWeb, but it doesn't show it on. Yeah, no, hold on.
It's just from a couple of days ago. I'm assuming they're just following the MAJ today.
On the,
Is that what you see, Dave?
Oh, you're right. They haven't filed the MAJ yet, but I can't see the processing queue in the 338. So
So-
file it will be this weekend.
at some point, they're also probably going to issue another warrant for your arrest because of all these cases now, because you're on probation. So at that point, you'll also probably have to set a bond on that one, or they may not set a bond. I don't know.
Right.
How old are you?
20.
You're 20?
All right.
Going the wrong way, Mr. Dunham. You're really, really begging for a lengthy prison sentence, dude. That's it. Okay.
Thank you, Judge.
Thanks.
Thanks, Judge.